Hi, everyone. You were assigned Chapter 4 for this week to read pages 87 to 107. What I have done is I've just put together a PowerPoint to discuss some of the major points I want you to take away from this chapter. It does not in any way replace your need to read the chapter, but hopefully this will assist you in understanding the concepts in the chapter and also will assist you on the assignment that you have for this week. So first we're going to talk about inchoate offenses. Inchoate means not yet completed or fully developed. These offenses involve solicitation, conspiracy, and attempted crimes. Solicitation is the act of asking another person to commit or help commit certain offenses with the intent that that offense be completed. If you look on the first page of the chapter, page 87, it gives an example of a person who was in jail and solicited two people to kill a deputy sheriff upon their release. Luckily, neither of them did it. They went to the authorities, but even so, that person who was in jail who had the specific intent that they commit those offenses, he was charged with 2 counts of solicitation to commit murder. Why is solicitation a crime? It is a crime because the law wants to protect people from being induced by others to commit a crime, and the law wants to prevent the commission of the crime being solicited. Because with more people involved, it's likely that the crime would be successful, and we don't want that to happen. In California, the elements of the crime of solicitation are the suspect requested or solicited another person to commit or join in committing certain crimes, including accepting a bribe, murder, rape, carjacking. That should be robbery. And then with the specific intent, the act solicited be carried out and the other person received the request. It's very important that the other person receive the request. The crime of solicitation is complete at the point when the solicitation is made if the solicitor, the person making the solicitation, had the specific intent that the crime solicited be completed. And again, you can go back to that example on page 90. That's the person who was in custody had a specific intent that each person he talked to, that they killed that deputy sheriff. That was his specific intent. There are also crimes where a particular type of solicitation is a crime, such as Penal Code Section 647B in California, which is soliciting a person to engage in prostitution or soliciting a minor to commit certain felonies, and then also soliciting a person to join a street gang. That's a particular type of solicitation. What's needed for solicitation? The law is reluctant to convict someone just based on the word of one witness. So we would have to have the evidence would need to be direct testimony of 2 witnesses or the direct testimony of 1 witness along with corroborating circumstances. What's corroborating evidence? It's just evidence that tends to connect the defendant with the crime and is independent of the evidence given by the witness. You could look at pages 89 through 90 of the textbook where it talks about a solicitor changed their mind about having a person killed, but the fact that they communicated the request and at the time had the specific intent that it be completed, it is enough. And I believe in that example as well, the police officer was on another line listening to the solicitor repeat her request to the person, repeat her statement to a person saying, yes, I hired so-and-so to kill my husband. So that was corroborating evidence. Conspiracy. The crime of conspiracy is an agreement among 2 or more people to commit a crime, and where at least one step has been taken to further the action. Again, the law recognizes the danger when more than one person is involved in criminal activity. In California, Penal Code Section 182 is the primary statute regarding conspiracy. You should check it out. It names a number of specific conspiracies, but there is a catch-all. It's a crime to conspire to commit any crime, including misdemeanors. So check that out for yourself. The agreement for a conspiracy can be expressed, meaning the parties actually talked about it, or the agreement can be implied based on facts and circumstances. For example, a group of guys rob a bank. It's very coordinated, it's well orchestrated. It can be implied that they conspire to commit that robbery. They didn't just meet each other on the street 2 minutes beforehand and walk in and commit it. Conspiracy is a specific intent crime. The parties must intend that their criminal objective will be achieved. So students joking about how they would rob Fort Knox would not amount to a conspiracy. The people have to have a specific intent that the crime be completed. See page 91 of your book regarding jurisdictions that follow a unilateral approach where even if one person is pretending they are agreeing to conspire, such as an undercover cop, the person who had the specific intent can still be found guilty. An example given is an undercover officer pretending she was meeting the defendant to have sex with her and her daughter. A Colorado court, the defendant said, hey, I can't be guilty of conspiracy because the police officer really didn't intend to go through with it. But the Colorado court said, no, you are still guilty of the conspiracy, even though the officer had no intent to carry it out. A bilateral approach, which is in California, requires that 2 or more people agree to commit the crime. If one person is faking it or is an undercover cop, conspiracy is not committed. The person may instead be charged with an attempt to commit a crime. The conspiracy requires an overt act. And this is something you have to communicate on the discussion assigned to you this week. For the conspiracy to be complete, there must be an overt act, any step taken beyond the agreement by any member of the conspiracy toward the commission of the crime. This also allows people involved in the conspiracy a chance to change their minds and terminate the agreement before this overt act happens. But what's an overt act? It does not have to be a crime in and of itself. It could just be anything that an act done in furtherance of the crime, such as going to Target and picking up tape, registering and buying a gun. What's also important is only one member of the conspiracy has to make the overt act. However, by doing the overt act, even one member, they have all acted. All the members of the conspiracy have acted by that one person taking that overt act, that step towards the commission of the crime. Liability for any natural and probable consequences. So any step taken in furtherance of a conspiracy, all conspirators are liable, including for any natural and probable consequences. So for example, Dan and Steve and Harry agree to transport drugs across the state. The plan is for Dan and Steve to hijack a car while Harry stays home. During the carjacking, the owner of the car is stabbed by Dan. Dan, Steve, and Harry can all be charged for the murder and the conspiracy to import the drugs. So because hijacking a car isn't a dangerous felony in and of itself, and there's a risk of someone being killed, Dan, Steve, and Harry, it's a natural and probable consequence. Dan, Steve, and Harry are liable for the murder and the conspiracy to import the drugs. Can a co-conspirator withdraw or change their mind? Yes. If a person withdraws from the conspiracy before any overt act takes place, they can withdraw. If an overt act has taken place, the person can still withdraw, but there are more steps required. The next step is a person must make a free and voluntary choice, not prompted by fear of detection or arrest, that he is withdrawing. And finally, he must communicate to the other conspirators, hey, I'm out of this. I'm not going to go through with it. Attempted crimes. Model Penal Code, which is followed by most states, requires the following elements for attempted crimes: an attempt to engage in criminal conduct and conduct constituting a substantial step toward the commission of the substantive offense that strongly corroborates the actor's criminal intent. That just means it strongly shows that the actor intended to do what he's alleged to have done, he's charged with doing. So see the example on page 96. The suspect was caught building a pipe bomb to blow up the car of a husband of a female he was involved with. Even though he had not yet attached the bomb to the car, it was sufficient to show he'd made a substantial step towards committing the crime. This is very important, parties to a crime. Now, under common law, it used to be that the law recognized principals in the first degree to be the persons who actually committed the crime. Principals in the second degree were recognized as the persons who were present at the crime but only aided and abetted in the commission. The law also recognized accessories before the fact, people who knew the crime was going to take place and aided in the preparation but were not there. Finally, accessories after the fact were people who knew the crime had been committed and gave aid or comfort to the person who had committed it. The distinction was that neither the principals in the second degree nor the accessories before or after the fact could be tried until after the principal of the first degree was convicted. Well, that was obviously a lot of work, right? So this is not the law anymore. Today, a principal is defined as all persons concerned in the commission of a crime, whether they directly committed the act, sometimes they're called perpetrators, or aided and abetted in the act. So now principals include those who directly and actively commit the crime, and aiders and abettors, those who aid and abet in the commission of the crime. How do you know the person is an aider and abetter? If the person before or during the crime in any way directly or indirectly aided the perpetrator by acts or encouraged him by words or gestures. Here's an example. Pam and Sherry go into the bank and rob the bank while Stacy waits in the car as a getaway driver. All three would be principals and guilty of the robbery. Even though Stacy's an aider and abettor, she's a principal. She was the getaway driver, and so equally responsible. In the prior example, if Stacy stayed home but knew Pam and Sherry were going to commit the robbery and let them borrow the car to commit the robbery, she's still guilty. Presence at the crime scene is not required. But look at this. If Stacy did not know about the robbery plans because Pam and Sherry lied about why they needed her car, then Stacy is not an aider and abettor, and because she did not know about the plans, and so she would not be guilty of anything. Accessories are known as those who know that the crime took place and they help to conceal, aid, or harbor the suspect to help them escape or avoid arrest. So an example, Lisa allows Pam, Sherry, and Stacy to stash the money in her basement. Lisa can be prosecuted as an accessory after the fact because she knew that the crime had been committed, and she helped them by having them stash the money at her home to avoid being arrested. It's interesting, in California, you can only be prosecuted for an accessory if a felony has been committed, not a misdemeanor. So you can check out Penal Code Section 32 to look at that. Remember, the principals, which includes the aider and abettor, are not only responsible for the crime committed, but also for any crime which is a natural and probable consequence of the crimes originally planned. So, for example, Stacy being the getaway driver, she would be guilty of murder as well if Pam and Sherry killed someone during that robbery. Can a person who refuses to give police information about a suspect be charged as an accessory? No. But if that person provides a false alibi for the suspect to the police, they can be charged as an accessory. All right, that's it for now. We will discuss more hypotheticals when we return to class next week, showing you the distinction between principals and accessories. Please bring any questions you want to ask and we will get them answered. Thank you. Have a good week.